Good afternoon, ladies and gentlemen. My name is Tom Elliott. I'm your moderator today. And today's presentation, just to make sure you're in the right one, is the new Condo Act Explained by Leslie McRae, who, as some of you know, is the Registrar of Land Titles at the Department of Justice, Government of Yukon. Just before I get on to a little more fuller introduction of Leslie, let me just go through a few housekeeping matters. This presentation today is brought to you by the Continuing Professional Development Committee of the Law Society of Yukon. There are 53 people who have signed up for this, so there's quite a few people in theory anyways, watching, and perhaps some of you are in the business of advising members of the public on condo law, or perhaps you're a existing or would-be condo owner yourself. Nonetheless, if you have a few other housekeeping matters, if you have any questions, you can put them into the chat room. If there's any need to let in late people, if anybody shows up in the waiting room, of course, we'll let them in. This presentation is being recorded and will be on the Law Society website later. And perhaps best of all, 1.5 hours of CPD credits. So there's some of the housekeeping matters for you. Let me just turn to Leslie McRae for a moment. Some of you know her, some of you work with her, and others perhaps not. But Leslie's been in Yukon for a long time, 1980, October 1980. And I had the pleasure of working with Leslie beginning in the summer of 1985, where I was articling, and Leslie was a very knowledgeable legal assistant, and I'm forever grateful on some of the files that we worked on together. Leslie was called to the bar of both British Columbia and Yukon in 2000, and over the last 22 years, she's practiced residential and commercial real estate, including lending and borrowing. And she had a long career at Northwestel. Some of you might remember her from her days at Northwestel. She held a number of roles: general counsel, corporate secretary, and chief privacy officer. And just about 15 months ago, January of 2021, Leslie was appointed as the Registrar of Land Titles, and I'm sure many of you know, if not all of you know, that those offices are in the Law Center and have been there since 1986. Okay, before I hand it over to Leslie, there are just a little bit of background information that I'd like to provide that refers to this particular presentation. Of course, I'd like to begin by acknowledging that this event is taking place on the traditional or in the traditional territories of two First Nations, the Kwan-the-Dun First Nation and the Ton-Quachin Council. As many of you know, the Government of Yukon recently approved new regulations for the Condominium Act, which was initially passed by the legislature in 2015. And those regulations will come into force soon, October 1st of this year. Leslie, when I turn it over to her, she'll review the different provisions of the Act, starting with a discussion of the new elements contained in the updated Act. And then she'll go through a discussion of, or an overview, I should say, of the new regulations. There's 6 regulations, as some of you know. And she'll also speak to, in the last part of the presentation, about the transitional provisions, which is always so important when you're moving from one legislative regime to another legislative regime. just by way of a bit more background, it's been a 10-year journey here. The Government of Yukon started public engagement to update the former Land Titles Act and Condominium Act in 2012. And at that time, it formed a stakeholder committee, the so-called Land Title Stakeholder Advisor Committee, which met on a regular basis and provided input to the government as it developed the policy and ultimately the legislative background to the new act. Yukon First Nations were also consulted through the Land Title Solution Working Group. The Condominium Act was approved by the legislature in May 2015. And as you'll see in the act, the government of the day was seeking to balance a variety of interests, be it developers, consumers, buyers. It also clarifies the governance requirements for builders, developers, and condo corporations. And just a couple more points here. During the development of the regulations, it became clear that further industry and public engagement was necessary, and that led to some significant amendments to the Act. The regulations were adopted by the Yukon Government Cabinet last month, and as I mentioned, will come into force October 1st. So at this point, I'm going to turn it over to Leslie, and I'm going to start just by asking her a question about the role of government in this new condo regime. And I'm going to turn the screen so you can see Leslie completely.
Thank you, Tom. Welcome, everyone. Condominiums are self-governing organizations. So the role of government, aside from actually passing the legislation and determining the regulations, is really to provide that framework, to provide information to developers, to the public who are going to be living with the legislation. Compliance with the legislation or with condominium corporation governing documents is not going to be monitored or enforced by the government. Dispute resolution provisions exist in the legislation, and condominium corporations have discretion to include alternate dispute resolution provisions in their bylaws. So I'm going to also let you know that we're working on with the communications branch of Government of Yukon Department of Justice on a page for condominiums that will be on yukon.ca, and I hope very soon. And that page will have on it the Consolidated Act, excuse me, a link to the regulations. It'll have some information fact sheets. It'll have our forms as we develop them, and it'll have other information as well, links to other useful resources like the CMHC, CMHC's website. They have an excellent condominium home buyers information website, which will be updated. They have a Yukon section, which is, of course, now reflects the existing act. So I'm going to open now. Oh, wait a minute. I should tell you a bit more about what we're doing in land titles. Our role is to prescribe the forms wherever you read in the act that something is prescribed, it's going to be prescribed by the Registrar of Land Titles. This is not necessarily going to make sense to everybody why the Registrar of Land Titles should be prescribing forms that are going to be used by the condominium corporations. So we live with what we have, and potentially we'll look at whether it works or doesn't work for condominium corporations. Those forms are going to include, of course, the forms needed to create a condominium corporation, to amend any of its governing documents, the forms that a condominium corporation will need to do annual filing, because there are in the new act annual filing requirements, as well as information certificates that the condominium corporation will have to provide to potential purchasers, mortgagees, lessees, for example. Our role is also at the Land Titles Office, as most of you know, to examine and register the condominium plans that once they've been approved by the Surveyor General's branch of Natural Resources Canada, they come to Land Titles for registration, to examine and register the declaration and amendments to declarations, to examine the first bylaws that are filed, not registered, but filed. I'll talk about the difference in concept between registration and filing, which is a new concept in the new act. Subsequent bylaws or amendments to bylaws and notices of directors, notices of address will be filed and not registered. You will be able to search for all of this condominium information through the Land Titles online portal, effective October 1. So again, as is the case with the Land Titles Act that you're, I'm sure, all familiar with, the Register of Land Titles, it's not the role of the Land Titles Office to interpret or give advice about the Condominium Act or regulations. When we develop forms, we will circulate the draft forms for practitioners to review and comment on, but we will not examine documents before they are submitted for registration. So we will develop examination criteria and publish that so that folks are aware of what our document standards are and what our practice standards are when we examine documents. So I'm going to open the act now, so I may disappear. And if I do this, I can't minimize Zoom while I'm recording this meeting. Okay, this is the first time I've actually led a Zoom meeting. So now I have to share my screen, says Lynn, and then I have to open. Maybe you will see it. I hope you are all seeing an unofficial consolidation of the act. Now, as you might recall, the act, although it was passed by the legislature, let's see if I can get that as big as possible. In 2015, it was substantially amended in 2020. Enter PDF full screen. Let's see if I can even get that bigger. Can I get that bigger? Then I've got the PDF on the screen here, but it is only sort of a full page view. And I'm not sure whether that's going to be a really good view for people viewing the webinar. How do I get it bigger? How do I zoom up into it? Exit full screen. I'm no doubt.
Exit full screen and just share the screen.
Okay. No doubt someone on the webinar is going, you do this, do this. See, that's just not a very good image for people to view. Fit to width. I think I did it better. I got it fit to width.
That's as big as.
And I think Lynn says that's as big as I can get. So this is an unofficial consolidation of the act with all of its amendments. And I have permission from Legislative Council to share this for educational purposes. Ordinarily, this unofficial consolidation would not be published until the act was actually in force. So I hope that to be able to very soon have this on the condo's webpage that I told you about. If it's not going to be very soon, I can make this available potentially by emailing it to the people who have attended the seminar. I don't want to get in the habit of emailing the legislation. It's very large. So I hope that if we can't get the condominiums webpage up immediately, that I will be able to post this onto the Land Titles Office. Land Titles Office has a webpage on yukon.ca. So we are working on that right now. So hold off on asking me to email it to you for now. So simply because of time limitations and given the size of the act, I really am just going to look more or less right now at the table of contents and identify what I think is new or expanded. It not too difficult. I mean, I think the existing Condominium Act 2002 is about 20 pages long. The table of contents for the new act is about 20 pages long. I'm joking. I think it's 12 pages, but pretty darn close. So not surprisingly, it's the act starts with the definitions, really expanded definitions for many things that were never defined in the old act. Confirmation that, of course, a condominium plan is a plan of subdivision. The whole first part 2 is all about creating a condominium, the steps that need to be taken to have a plan approved, the concept, new concept of unit entitlements rather than a percentage of the property, unit entitlements. And when we look at the general regulations, you'll see how unit entitlements are required to be calculated. Concept of notices of address for service, first directors and bylaws, and the conduct of the condominium index and register. And this is quite a new concept. I will be keeping a condominium corporations index. It does exist now. We are using it in the background. You can't see it right now if you logged onto the portal, but we use it, in which we have a corporate records folder. And as of October 1st, for each existing condominium, that corporate records folder will be populated with the bylaws of every condominium and the documents that are required to be filed rather than registered will be in that folder as well. So that is a new concept. Now let's see if I can cleverly get back to where I was. I'll go to page 3 and see what happens. Oh, that was a good guess. Okay. So, oh darn, I just closed it by mistake. I got it back. So that's part 2 of the act, creating a condominium. It goes through the registration procedures as well. Part 3 of the act tells you about titles, unit ownership, common properties, use of the units, common assets and common property. All are quite familiar concepts. The other new concept is the common assets, that a condominium corporation can own assets, which are called common assets, which may be a unit in the condominium development or may be a separate piece of real estate. And if the corporation does own common assets, there's a requirement to issue a certificate of common assets. There's a whole section on implied easements now. There was a very small section in the former act, but it's greatly expanded in terms of implied easements that now exist on the creation of a condominium. There's more information here about the Division 3 about other common assets and acquisition and disposal of those assets. Then we're moving into Division 4, provisions for transfers and encumbrances, including leases, easements and restrictive covenants, and how they are registered and how they burden the condominium parcel. Then there's a new little section on work orders and builders liens. Part 4 is also a new section, and new concepts. As people who are familiar with condominiums in other jurisdictions are familiar, the Act contains provisions that require the developer to make disclosure to potential purchasers of units, to include cancellation rights in contracts of purchase and sale, and to hold any money in trust, which is not an uncommon concept. It also has provisions for if the developer is going to give possession of the unit before the condominium application is registered at land titles, and which I'm sure most of you know that's a really common thing, that the developer frequently obtains occupancy permits from the approving authority, and people move into the units before the actual condominium is created in land titles. The next section of the act, the next part of the act deals with condominium governance, and many of these provisions are new but should not be unfamiliar. You know, confirmation of how the corporation functions. Of course, it functions through a board of directors. What the powers and capacity of a condominium corporation are, who is eligible to serve as a director, all set out in the act. Standards of care, duties to disclose, conflicts of interest, very, very familiar corporate governance concepts. I'm sure to all of you are now actually set out in the act. There's a new section that deals specifically with how does the developer transfer control from him or herself to the first directors of the condominium corporation, and how then do those first directors transfer control after a transition period to the unit owners board of directors, if you think about it. So that's all set out here, as well as the requirement for that first board of first directors to deliver essential documents to the condominium corporation elected board of directors. Also, as in this section is provisions for meetings of the unit owners and other eligible voters, the businesses that they are required to conduct at annual meetings, special meetings, resolutions in lieu of meetings, quorum requirements, electronic attendance, which was a considerable gap in the former act, as some of you may know, if you sit on condominium corporations, that during COVID, when you know people were not able to meet in person, we had a lot of inquiries at the land titles office about whether or not we could hold our meetings electronically. The next division deals with voting rights, proxies, how they're exercised, passing resolutions in lieu of meetings again in this section. A big section on bylaws. I'm kind of joking about that because it's not a big section. It's just a little section about bylaws and rules, which should be familiar to most of you who've worked with condominiums, of course. The bylaws are filed at the time the condominium is created, and this section sets out what may be in the bylaws, what must be in the bylaws, and how bylaws can be made and amended. There's a new section that talks about rental restrictions and the requirement for the landlord, the unit owner, to give notice to the tenant of bylaws. And then there's a little section here. It's on another sort of new concept. I'm sure everyone's familiar with a mixed-use development, which may have retail or commercial space on the ground floor, and then what is considered sort of conventional residential units on upper floors. The Act gives the condominium corporation and unit owners the ability to create separate bylaws for each of those sections. So one set of bylaws for the commercial section and one set of bylaws for the residential section as well. And then how those sections work together. The next section talks about enforcement of rights and duties, and this is where you'll find the voluntary dispute resolution process and everything to do with that, as well as procedures that are necessary to evict a tenant for breach of the rules of the condominium. I've just realized that I can't tell if anyone has their hand up. So I hope there's no one out there jumping up and down wanting me to dive into a particular section. And Lynn's going to try to look for me to show me where I would see that.
Be across the top side in a full screen.
Mm-hmm. Give me a view. Yep, it's all there.
Okay, can you leave
So-
that open for me as I
It kind
navigate?
of disappears. You just have to go.
I just have to hover up there and it'll pop
Right.
up. Okay, sorry about that, folks. I just didn't know how to find it. And I'm trying to keep an eye on the time at the same time. Yeah. To make sure that we do have time at the end. My concern is that if someone has a question about a particular section of the act and we dive into that, we may not get back out again to look at this sort of overview or to look at the regulations in any detail. So part 7 of the act deals with finances, budgeting and financial statements, most of which are also new concepts in the new act. And a critical new concept is, of course, the establishment of the reserve fund, which is dealt with in section 136 of the act. The developers requirements, and then later on in the act, there is the requirement for the condominium corporation itself to maintain a reserve fund to adjust for the difference between actual and estimated expenses during the transition period, transition from the developer to the elected board of directors. There's a section setting out the requirements for how fees and expenses between the first annual meeting, when the first directors hand off responsibility to the elected board of directors, as well as provisions for budgeting and financial statements after that second annual meeting. Division 6 deals specifically with the reserve fund studies and decisions on when you have to make contributions to those. And we'll look at the reserve fund regulation. It's very short, and it deals primarily with who is a qualified person. The next section, Division 7, is about what the condominium corporation's rights are if it's charging fees and fines and interest on late payments, giving notice to unit owners and tenants, how a condominium lien is created and filed, and how the condominium corporation proceeds to enforce that lien. Part 8 deals with insurance. Insurance, as I'm sure everyone who gives advice to a condominium corporation or is a unit owner themselves or sits on the board of a condominium corporation, is at the forefront of many people's minds, because not only because the premiums have gone up so much, but the coverages are being narrowed, additional restrictions are being placed by insurance companies on condominium corporations where a majority of units are in fact rented and not owner occupied. The government's concern here was, again, to provide flexibility to condominium corporations and their unit owners in decision-making about the types of coverages, the types of general liability insurance, the deductibles, to put some more flexibility into the hands of unit owners as well, in terms of those coverages. And when we look at the general regulations as well as the transition provisions, we'll talk a little bit more about that. And now we're going into condominium management. Very exciting stuff for those of us who shuffle a lot of paper. That the Act makes it more explicit now about what records the condominium is required to keep, maintain, prepare, distribute, provide, primarily through the concept of information certificates. Section 186. I hope in the future there'll be an opportunity for practitioners and condominium corporations to have an information session or an education event that really goes into information certificates in more detail. Because right now, I think everyone who practices in the area is familiar with the concept that when you act for the buyer of a condominium, or when you act for someone who's lending money on the security of a mortgage for a condominium, you ask the condominium corporation for a certificate. that has some fairly limited information in it. It basically says, is the owner in default? Are there any outstanding assessments? What's the insurance coverage? The information certificates now, a potential purchaser, lessee, or mortgagee. I'm not sure if there's another category. I might have missed a category there. But those are the key categories. Can request from the condominium a certificate that deals with more than a dozen items, and can go into significant detail. So the form of information certificate is going to be a prescribed form, and we have drafted it. I do think, as I mentioned at the beginning, that this is an area where that we need to explore with condominium corporations why that form needs to be a prescribed form by the Registrar of Land Titles. That makes me scratch my head. So the next section is on contracts for management contracts, methods for giving notice and providing information, corporate notices to be filed. Again, this concept of filing. I'm just going to peek at that. What constitutes filing is filed in the corporate records folder. So it's not a registration. It won't be submitted for registration. It won't be examined by land titles. It won't be registered by land titles. It will be filed by land titles in the corporate folder, and an acknowledgement of that filing will be provided by the land titles office. One of the things that condominium corporations will have to think about, though, is that when they're amending their bylaws, the bylaws are not effective until they are filed with the Registrar of Land Titles. And so that's one of the reasons why it's important that the registrar is able to give confirmation of filing. So it's filed by the registrar when it's received and entered in the folder. That is a new concept, a very new concept. See if I can get back to where I was before, or if I'm going to end up somewhere completely different. I'm zipping through. Okay, so we've been through finances, financial management, insurance management. Here we go. Fundamental changes, part 10 of the Act deals with essentially how you amend the declaration, particularly as it relates to the use of common property, adding or canceling designations of common property are all dealt with in this section of the Act, amending the plan, amending the declaration, and the requirements to do that. The other types of possible amendments that you could make, the concept of amalgamating adjacent condominiums. And then I think we're getting close to the end here. The legal proceedings and arbitration section, which is not going to be a surprise to anyone. How to start proceedings and maintain proceedings against a condominium corporation or by a condominium corporation. What capacity the corporation has to sue as representative of the unit owners, in other words. And then a section on proceedings between a condominium corporation and the unit owners itself. Part 12 of the Act deals with terminating a condominium corporation, either voluntarily or by court order. And then the general section, the typical lengthy regulation making powers of the commissioner, and a little section that we have in the Land Titles Act, which says that the Registrar of Land Titles may prescribe forms. I think the word it uses is may determine forms. I've determined that I want to have a form for this, and it has the same effect as being prescribed. So I know that was a race. That was a race through the table of contents, and I hope at the end that if any of you have had questions about specific sections of the Act, that we will have time to deal with them. Otherwise, as I have mentioned, I think I mentioned, we'll compile all the questions that people ask and we'll circulate a Q&A to everyone who's attended. So what I'd like to jump into now, though, is the regulations themselves. There are 7 regulations. One of which I think just deals with the coming into force of the Act. There are 3 regulations that deal with specific types of condos. Bare land, special rules for bare land condos, converted building condos, phased development regulations, and condominiums on leasehold land. There's one little bitty regulation that deals with the reserve fund requirements. And then, of course, there is a general regulation. And so I'm going to jump to those. They are, of course, published in the Index of Regulations on the government's legislation website. And I'm going to look at them sort of in the way I just mentioned them. So first we'll look at the bare land condominium regulation, then converted, then leasehold, then phased. And then we'll look at the reserve fund regulation and finally the general regulation. And I hope that will still give us plenty of time to look at the regulations and the applicable sections of the Act if you wish to, and still at the end, look at transition provisions in the Act. Because I think those are really important, and that probably most people are most interested in those transition provisions and still allow time for questions. So looking at the bare land condominium regulation, it really is just specific to what has to be in the declaration for a bare land condominium that is unique to bare land condominiums and not other types of condominiums. Pretty basic, that it contains only bare land units, or if it's phased development, it could potentially have both bare land and, as you think it conventional, whether there or not there's managed real estate, or a statement that there's not managed real estate. Developers are going to find under the new Act that they're making a lot of statements. Also a positioning certificate is required to show the position of attached buildings. We don't normally think about bare land units having attached buildings, but they do. And how those are monumented under the Canada Land Survey Act and regulations. One of the things that you'll see in the regulations and in some places of the Act are things that say evidence satisfactory to the registrar. I have to tell you that at this point in time, the registrar has not yet decided what that evidence might be. So there'll be plenty of communication to practitioners, as well as published on the condo webpage. Once the registrar does decide what evidence is satisfactory, to explain those standards. I don't think it'll be anything freakish, but it might involve delivering cake to the land titles office. I got to tell you that right now. We have a thing for cake. So really, that's really all there is to the bare land regulations. That requirement, and there's some prescription here. What is managed real property? Well, here now this is managed real property. The roof of the building, shingles, sheathing, underlayment, flashing, exterior finishing, exterior doors, including the door frame. Don't forget the door frame. And exterior windows, glazing, window frames, and window assembly. Very detailed list here. And then any structure or non-structural improvement that's constructed across more than one unit, which might be a retaining wall, for example. And all areas within easements for services or utilities. So those bare land units are very popular forms of condominiums. So anyone giving advice to a builder developer needs, of course, to be familiar not just with the provisions of the Act, but in particular with the provisions of this regulation. I don't need to tell you guys that. So that's it for the bare land regulation. Wasn't that easy? So the next one is converted. Now, I don't know. I don't have any sense. Maybe you folks out there might have more sense than I do about whether this is going to be a popular concept, whether there are going to be owners of apartment buildings who want to convert their apartment buildings into condominiums. If they do, this regulation is the one that tells them the things they have to pay attention to. They have to work with the approving authority. They have to obtain a building assessment report based on an inspection and get that building, submit that building inspection report to the approving authority, the subdivision approving authority. The building assessment report has to be prepared by an arm's length person who is qualified, an engineer, for example, a person who's licensed to practice as an architect, or another person that is specified not by the Registrar of Land Titles, but by the approving authority. So the approving authority, subdivision approving authority could determine that there's a class of persons or a type of persons or professions that are qualified to prepare building assessment reports. The building assessment report, it has to go into quite a bit of detail, and particularly in terms of identifying any deficiencies, any variances to building codes, especially as it relates to the building envelope itself, because of course, those are going to be responsibilities of condominium corporation and affect the amounts of assessments that unit owners will pay. Things like drainage, load bearing, also any deficiencies with respect to the Fire Prevention Act, relating, of course, to smoke detectors and fire alarms and things like that. Emergency exits. It also has to include the results of a survey of the building occupants. The building assessment report has to, the person who's performing that report has to make a survey of the building occupants and gather from them any observed problems. And then there's a list of things that it may include, a short list of things that it may include. If there was a limitation of the inspection, for example, given our weather conditions here, that may just include things that the inspector was unable to determine because they was not able to inspect because of snow load, for example. And also include, recommendations about other investigations that may be made. The regulation also includes requirements for the approving authority. What does the approving authority have to do once it receives the building inspection report, and as well, the fact that the approving authority has to establish rules regarding procedural aspects? That is the responsibility of the subdivision approving authority. And then there is a section that deals with delivery to a potential purchaser of a unit in a converted building, a list of deficiencies. There's special provisions, special rules about the reserve fund requirements for a converted building. And some of these, of course, do not apply if the converted building has not more than 2 units. There are tenants' rights established in the, oops, I didn't mean to slide that far ahead. There are tenants have rights, tenants who occupy a building which is going to be converted have rights. And one of those rights is the right, a conditional right to purchase the premises from the developer. And notice of that has to be given to the tenants at least 6 months before the application to create the condominium. And it has to be made on certain terms that are specified here in the regulation. And the regulation also establishes that if in certain circumstances, the developer is not required to make an offer for sale to a tenant. Either the type of premises is changing, or certain units are going to be merged or subdivided. So, you might have an apartment, 2 one-bedroom apartments. If the developer plans to merge that into a single 2-bedroom unit, the tenants of the one-bedroom units would not be entitled to receive an offer to sell them those premises. And the same if there's a 2-bedroom unit, 2-bedroom apartment that the developer plans to convert into 2 one-bedroom apartment or units. The tenant of that rental apartment would not be entitled to receive an offer for sale. And here's something else, another statement that developer has to give in a form acceptable to the registrar about whether the developer has complied with those requirements. And then a little small section about the type of additional records that for a converted condominium must be kept by the condominium corporation, which not surprisingly is the building assessment report and the reserve fund study that the developer would be required to do. The next regulation we're going to look at is phased development. Phased development, as many of you know, has been controversial, primarily because of the potential for changes to be made by the developer in the development of subsequent phases of the condominium. So this regulation is very much about how the unit owners of phase 1, the first phase, will be protected through a variety of disclosure requirements and consents that they must give from changes to what they agreed to when they purchased their units. There is an extremely detailed disclosure statement that the developer must make, and that has to be delivered to any potential purchaser of the first or any subsequent phases. Although there is the ability for the developer to amend a subsequent phase, it is somewhat restricted and requires, of course, consent and additional disclosure. That phase development disclosure statement must be registered at land titles, so it becomes a public document. And then, of course, there are special provisions for transition from one phase to another phase and what happens if the phase is not completed as required. So I just want to look quickly at the requirements that are going to be in a phase development disclosure statement, because there are quite a few of them. The disclosure statement has to contain a lot of information. First of all, a statement that the parcel is going to be developed in phases, the number of phases, the dates by which registrations will be made with respect to each phase, the statement of the dates by which each phase is to be completed and the final phase is to be completed, a statement of the number of units or the minimum and maximum number and type of size and approximate size of each unit in each phase and in the total completed development. A detailed description of the units, the common property, the exclusive use common property. You would expect to see that in a declaration in any event, but it'll be by phase rather than just, all listed out. A detailed description of the common assets, if any, and any exclusive use common assets. A statement of the restriction or qualifications on common property and the type of units that are to be included in each phase. Some of these are not going to be surprising because it would be what you would expect to see in a declaration, as I mentioned. The visual representation of the phases that shows what the next phase is going to look like, what each phase is going to look like. a description of the architectural compatibility of each phase with each other and with the entire development. If common property is going to be available to unit owners, for example, a swimming pool or recreational facility, when is it going to be available to the owners? All of these things are going to be really interesting to potential purchasers of phase 1 units in particular. The same type of information with respect to common property and exclusive use common property and exclusive use common assets. When are they going to be available and transferred to the corporation? When is the corporation going to be responsible for their maintenance and repair and upkeep and insurance, for example? How the unit entitlements are going to be calculated in relation to the initial phase and each subsequent phase, because of course, as each phase is brought in and registered, there will be the need, I assume, for recalculation and reallocation as a result of a subsequent phase. In addition, voting rights may change or be determined differently in subsequent phases. Statements of the way that the basis on which common expenses are going to be allocated, how the developer will contribute to those common expenses in each phase. And finally, a contingency plan describing the consequences of a phase not going ahead and what the impact of the existing unit owners is going to be at that time. And then there's some other certificates from the approving authority, from the developer that it complies with the regulations, all of which must be disclosed by the developer to a potential purchaser. There are special requirements for the condominium plan. I'm sure that doesn't surprise you, in a phase development and the need to file supplementary plans, to obtain consents from registered encumbrance holders. I keep calling it supplemental plan. It's actually a supplementary plan. And how and when that has to be prepared and submitted for registration as the phases develop. Notices that have to be given by the developer to condominium, each unit owner, as well as the condominium corporation. And what information has to be shown on the supplementary condominium plan is set out in the regulation. So the phase development regulation is quite detailed. And again, it is really focused on how to protect the unit owners of the initial phases and ensure that they have been informed and that all of this information has been disclosed to them at the time they purchase their units. So to try to eliminate any element of surprise and as well to control the ability of a developer to change subsequent phases without the consent of the initial, the owners of the initial phases. And then it tells me what the Register of Land Titles must do when a supplementary plan is submitted, and the impact on the existing unit owner titles, and how the Land Titles Office deals with the plan essentially, and any new bylaws. And there are timeliness provisions here. The developer has to give notice within a certain number of days, 5 days of receiving confirmation of registration of the plan. Notice to the condominium corporation and each unit owner, advising them of the registration. In addition, there's provisions in the regulation that deal specifically with amendment of the initial bylaw. That the condominium corporation is constrained without the consent of the developer or a court order. Particularly if it relates to activities relating to the sale or rental, restrictions on the age of persons who have access, advertising, and a requirement that the condominium corporation not make a bylaw that conflicts with the registered phase development disclosure statement. And then the developer's duty to actually carry out development in accordance with those, the registered plan and the phase development statement. The requirement to register. The developer must not apply to register it unless the consents have been obtained. Or what to do with an amended phase development statement, going to court if you need to. And all the requirements to comply with an amended phase development has to comply with, as usual, municipal zoning bylaws, land use, and any other laws. Registration of an amended phase development disclosure statement. And then here's the transitional provision. You know, when a supplementary condominium plan is registered that creates a subsequent phase, for example, there's a requirement to temporarily increase the number of directors on the board during that transition phase to ensure that the unit owners in the initial phase, as well as unit owners in the latest phase, are properly represented on the board of the condominium corporation. And that's structured based on the number of units in the initial and subsequent phases. And what the terms of those directors are is also set out in there in order to, you know, bridge the gap between the, you know, phase 2, phase 3, and final phases. Also requirements, the regulation, also sets out requirements that the condominium corporation must hold special general meetings within a certain time period after the sale of the first unit in a subsequent phase. Again, this is to ensure that condominium unit owners in subsequent phases are aware of expenses, financial statements, budgetary requirements, and all of those things that the initial unit owners would already be aware of. The developer's duty, again, to complete the phase development on time. And what if they don't? How the developer can change a date of a subsequent phase with the consent of the unit owners. What happens if there's a delay or it's not going ahead? Again, you know, I can't emphasize enough that condominium corporations are self-governing. The government won't be monitoring whether or not a developer meets their obligations under this regulation. So it's important that these provisions be in the regulations so that condominium corporations understand what the provisions are if a developer fails to meet their obligations. And what happens if you end up in court? There's a section in there. What about easements against common property in a phase development? This is a section here in the regulations that talks about how those easements work, when they take effect, how they might be discharged, and then finally, record retention. Condominium corporations that are a phase development, of course, have to keep additional records, which are, not surprisingly, the supplementary condominium plan and each registered phase development disclosure statement and amended phase development disclosure statement. Phase developments are complex. You know, I really hope that there'll be more opportunities in the future before the Act comes into force to meet with practitioners and who give advice to both developers and condominium corporations, as well as condominium corporations themselves, about the contents of not just this regulation, but other regulations as well. I also think that it's important for condominium corporations to understand that a pre-existing condominium could become a phased development. If there is a pre-existing condominium and the condominium corporation eyes some land beside it, potentially you could add a phase to an existing condominium, which is kind of an odd concept when you think about it, but it's possible to be done. So that is the phased development regulation. It is, in my view, the most complex of the regulations, but it really is about the balance that the government is striving to achieve between, allowing developers the flexibility to build the types of units in a structured way over time, and protecting the interests of unit owners and ensuring they receive all of the information that they need to receive, not just as the initial unit owners, but as prospective purchasers of units in future developments. So the next regulation is the regulation that deals with condominiums on leasehold land. And I'm really not going to spend any time on condominiums on leasehold land at this point in time, because they're not condominiums on leasehold land are not available really to anyone other than the Government of Yukon. And you can imagine that Yukon Housing is very interested in this regulation. Also, First Nation governments who are eligible to bring their land under the Act, their settlement land under the Act, are potentially a public authority under this regulation, and municipalities as well. So really, the regulation is just about how it works. Who is a public authority? Who does it apply to? What are the provisions that have to be included in a ground lease? What the heck is a leasehold condominium agreement, and who does it apply to? How do you apply to land titles to create a leasehold condominium? Additional information and documents that you have to disclose, and what the effect of registration is. How does it affect the source parcel and the primary title? The fact that the ground lease is paramount over, it prevails over the condominium plan and declaration. And then again, the concept of provision of documents to potential purchasers and certain other rights and obligations, that the ground lease and its information has to be given to potential purchasers, for example. And then what happens at the end of the term of the ground lease? So first of all, your ground lease has to have a term of 60 years or more. And 5 years before the end of that term, the public authority must give notice to unit owners and the condominium corporation of the expiry of the ground lease, particularly if it's really going to expire and not be extended or amended or renewed. And then again, has to give notice again, I think 6 months before the end of that. There's special provisions that apply on termination. A condominium corporation could not apply to terminate the condominium corporation and to terminate the condominium development itself without the consent of the public authority. I think that just makes sense to everybody. And I think that's really all I was going to say about condominiums on leasehold land, simply because they're a very sort of specialized area. I know that they are important, particularly in terms of the First Nations, wanting to do land development. And happy again to have other conversations with folks about how that's going to work. What is going to be necessary to create a leasehold condominium. And so the other two remaining, regulations are, first of all, the reserve fund regulation, just a little tiny regulation that basically says who is a qualified person, who is qualified to do a reserve fund study, who is that person, and how frequently do we need to do a reserve fund study. And essentially the answer is once you do have to do one, once a condominium corporation is subject to that section of the new act, it has to be done every 5 years, essentially. What has to be in it? Not surprisingly, the cost. What are the estimated costs? What are the likely costs of major repairs or replacement of the common property and common assets? And a whole bunch of factors that you cannot ask me to explain this. No one would ever hire me for my math skills or my understanding of general accounting principles or actuarial stuff. So you can't phone me up and ask me to interpret anything to do with this regulation because I will roll my eyes and pass out probably. But I can tell you who a qualified person is. That's who you're going to ask to interpret this section of the act. Those little pieces of the act and regulation that deal with the information that has to go into a reserve fund study, the factors and assumptions, including interest rates and rates of inflation. You will be able to ask these qualified persons. The chartered professional accountant, a fellow of the Canadian Institute of Actuaries, a member of the Appraisal Institute of Canada, an architect. That one kind of surprised me. I wouldn't have thought that architects would have been able to do those calculations, but obviously I've been undervaluing architects for many years. Certified reserve planners, who knew that there was such a thing? Real estate appraisers and professional engineers. Who is not eligible to be a qualified person? These people are not eligible to do a reserve fund study, the developer of the condominium, and anyone who is not at arm's length from the condominium corporation. As well, there are requirements with respect to condominium developments have less than 12 units. The board of directors of the condominium corporation can authorize someone to be a qualified person who is in fact not at arm's length from the condominium corporation. And then what happens after a reserve fund study is done? A copy has to be made available to each unit owner and each eligible voter. They have to receive notice that the reserve fund study has been done. My own thought is that the easiest way to make it available would be to file it in the corporate records folder at Land Titles. And then people can just log on to the online portal and search for it and find it. That's my own thought. No requirement to do that. They can, if they wish to, as you see here, may file a copy of reserve fund study to be kept in the corporate records folder. It just seems to be sensible. And if your condominium corporation is not large enough to have its own website, where it might have a members only portal, where it could put this type of information, it just seems to be sensible to me that it would be in the land titles. But of course, that does mean that it's publicly available information if it's filed. If it's filed, it's accessible to any member of the public who cares to go and look. And finally, the last regulation is the general regulation, which not surprisingly covers dog's breakfast of items from the Act. It contains more detail about information that has to be delivered to potential purchasers of units. It contains information about cancellation rights. The additional information essentially deals with details of court actions, property insurance, details of any special resolutions that the condominium corporation may have passed that deal with decisions not to obtain particular insurance against particular perils, for example, or to reduce the amount of coverage of a particular peril or to increase the amount of a deductible. Those are matters that have to be disclosed to potential purchasers. Also, how cancellation rights have to be set out in purchase agreements. The most interesting thing, something that I think is the most interesting thing is unit entitlements. And it's only because unit entitlements are quite a different concept from what is now very familiar to condominium owners is, you know, you own your unit plus you have a percentage of the common property. And now what you're going to have is you're going to have a unit entitlement. And this is the section, this is the regulation that establishes how a unit entitlement must be calculated. And it's important for folks to understand that this will apply to pre-existing condominium corporations going forward. So you're governing, we'll look at this in more detail in transition. I think that would make more sense. Because I think that condominium corporations are going to look at this concept of unit entitlements and feel that it does actually provide a better basis for calculating assessments, unit assessments, than the existing way of doing it. So I think that it wouldn't surprise me to find, especially for larger condominiums, that unit owners, I think, will decide themselves that this is more fair. It is more equitable to calculate based on this calculation. That's going to be my guess. I guess time will only time will tell whether I'm right or not right. It's because it's provides for adjustment for exclusive use of common property and assets. And it is more subjective. And I think especially, it might not be as important as for really large units, but I think for smaller condominium corporations where there is significant benefit to particular unit owners of common assets, that exclusive use, there is value to that. And so I do think that once condominium corporations have gotten used to governance under the new act, it is something that condominium unit owners are going to look at and say, hey, that let's do that. That sounds like it's more fair. But I could be completely wrong, because there might be, of course, the other side of that, which is I'm happy with what we're paying now and I don't want to pay anymore. The general regulation also contains the definition of what is a special resolution. What is the prescribed percentage? So I'm sure most folks won't be surprised to know that it's 70%. It also contains provisions about amending a declaration and what the percentage is that you need. A funny little requirement that a condo court may, in its bylaws, require that condo fees be payable on a basis other than in advance on the first day of the month. I just think that's funny myself. I don't know why. The maximum fees that a condominium corporation can charge for certificates, don't forget, information certificates are going to be very different. The maximum fee that a corporation may charge for an information certificate is $50. Information certificates, as I remind you yet again, very different going forward than they have been in the past. The condominium corporation can charge user fees for temporary or exclusive use of common property. Here it sets out the permitted investments by a condominium corporation. A little section that deals with an adjustment. And we talked when I raced through the act, the table of contents of the act, you'll recall I talked about how expenses are calculated during transition periods. Transition while a development is perhaps still under construction in phases, or transition between the time of the first directors before the elected board is in place. And so this is just a little section that talks about how during that period additional expenses can be calculated, or when they can be calculated. Provisions about annual meetings, and if the developer don't forget that although there are first directors, it is still essentially the developer who controls the condominium corporation at the beginning. And so there is a fine that the developer would have to pay if the first annual meeting is not convened during the time period that the Act prescribes. Just to try to keep that procedure on track. The next sections of the regulation deal with the budget that has to be presented at the first AGM, financial statements at the first AGM, budget and financials at the second and subsequent AGMs. More information about information certificates that includes the financial statements and budget. So not just the information certificate itself, but documents that have to go along with it, such as the bylaws, things like that. Here is the section that says the prescribed perils that a condominium corporation must insure for: lightning, windstorm, precipitation, water, escape, smoke, explosion and implosion, strike, vandalism, and a malicious act. So I believe that those are, I'd have to actually go back and look at section 170 of the Act to do that. And I think that those are the perils that the condominium corporation can choose not to insure for. The minimum amounts that the condominium unit owner is required to maintain for general liability insurance. And what if the bylaws don't require the condominium unit owner to maintain general liability insurance? A section about fines, the maximum amount for the contravention of a bylaw or a rule, the maximum frequency for the imposition of a fine, and a retention of records. And what happens if the records are not returned by manager to the condominium corporation. I'm sorry I raced through that quite a bit, but I am keeping an eye on the time, and it is really getting along. And I did want to spend more time on transition. And so I'm gonna close down this regulation, and I'm gonna go back to the Act, and we're gonna look together at section 239. Which is the transition provision of the Act. So I wanted to look at transition from two perspectives. From the perspective of a builder developer, and from the perspective of the board of directors of a pre-existing condominium corporation. So builder developers who may have a condominium under construction this year and don't know when it is, what is the line in the sand that determines whether the new Act is going to apply to their condominium that's under development. And that question is answered in this definition of substantially advanced. So if a builder developer has a condominium development under construction, it doesn't relate so much to whether the building itself is substantially advanced. It's whether the documentation that supports the creation of a condominium is ready. So has your plan been developed? Is it ready? Could we register it under the old Act if we wanted to, or if it wasn't for the fact that this new Act is going to come into force? So, and if you're ready, basically, if your documents are ready and could be registered under the old Act, then if that is the case, on October 1, the builder developer could register on or before the end of October, whereas it says on or before the 30th day after the enforced date. And then designate their development as a pre-existing condominium. So that's dealt with in section 239. Sorry, sub 1, sub 3, which I've just zipped past. I went by too fast. Here you go. Where arrangements evidenced in writing, isn't that a nice old-fashioned phrase? So where your documents are ready and you're ready to incorporate, you're ready to register. Okay, so if particularly your plan is ready, because that's going to be the key, I think the key thing. If the plan's filed for registration and the declaration is submitted for registration on or before the 30th day after October 1, then the developer could give written notice to the Register of Land Titles. Why I would care, I do not know. Designate the condo corporation as a pre-existing condominium. The developer has to make that choice at the time that the plan is submitted for registration. That is the key element. So essentially, get your plan registered before October 30th, October 31st, and you can choose to be a pre-existing condominium. And then all of the transition provisions that apply to pre-existing condominiums will apply to your new condominium development. I don't pretend that the transition section is easy to understand. But that's the key feature. For pre-existing condominiums that don't fall within that designation by a builder developer. So in order, ones that have been built, registered, and have got people living in them, what sections of the Act apply to you when they apply to you. There's sort of three categories where it's important, where the transition sections sets it out. And that is, of course, when do we have to have a reserve fund study? When do we have to have a reserve fund? When do the insurance requirements of the new Act apply to us, and when don't they? And the answer for the first part of that is based on the age of your condominium. If your condominium was created at least 10 years before October 1, then the sections of the Act that deal with the requirement for a reserve fund and a reserve fund study do not apply to your at least 10 years old condo for 5 years after the enforced date. And before that 5 years is up, the condo corp could pass a special resolution that fixes a different date. So 5 years without any action by the condominium corporation, additional years by special resolution of the condo owners, and they can continue to do that ad infinitum. So the owners of a condominium corporation, or the owners of condominium development that is more than 10 years old on October 1st, can choose to never have the reserve fund requirements and reserve fund study requirements apply to their condominium, initially for 5 years. And then the unit owners would have to vote and pass a special resolution each year after that to determine that those requirements will not apply to their condominium corporation. For all other condos who are younger than 10 years old, it's 5 years after October 1st. And there is not an option to opt out of the requirements for the reserve fund or the reserve fund study. Similarly, but a different time period for insurance requirements. And I see we are now at 1:25 based on the clock here. So I'm very sorry. I hope that I would have more time to talk about transition requirements, but essentially the requirements of the new act do not apply. And section 17 of the existing act continues to apply for 18 months after the new act comes into force. But the condominium corporation can choose to have the requirements of the new act come into force earlier than that. And that's the section that we're looking at right on the screen right now, which is subsection 6. So I think Tom is poised to seize the computer from me. Thank you very much. I hope that we'll have an opportunity in the future to do other sessions, perhaps focus specifically on creating a condominium or on giving advice to the condominium corporation on matters of interest. Generally speaking, it's going to be insurance, isn't it? It always seems to be insurance. And there will be other public information sessions and education sessions in the fall. I'm working with the communications branch of Department of Justice on figuring out when and how those will be held. Thank you. Thank you very much for attending and for your interest.
Well, thank you very much, Leslie, for that presentation. You've shown us that you are clearly our learned friend in so many ways, and certainly when it comes to the new legislative framework for condominiums in Yukon. Your dry humor was appreciated, as well as your editorial comments, which I'm sure were duly noted. And your sort of professorial way of presenting, very much appreciated. There weren't time for questions, but if you do have questions, please let the Law Society know. And as Leslie has already indicated, a Q&A answer sheet will be put together in due course. So thanks for that whirlwind tour. October 1st is coming, 6 regulations, a lengthy act, and many provisions, some that perhaps were a bit surprising, but that was the purpose of today's presentation. So I'd like to thank all of you for attending. I'd like to thank, of course, Leslie. I'd like to thank the Continuing Professional Development Committee of the Law Society for really arranging this. And I'd also like to thank the Law Society Yukon staff, including Lynn Piggage. You can't see her, she's off camera, but she's been sitting here duly attentive for the last 90 minutes. So thanks to all, and I hope you enjoy the rest of your day in spite of the fact that it's cloudy and rainy. Take care.